Bon dia a tots i felicitats en este dia de Diada a tots també. La primera parte o la parte de inauguración, first part, is about we have Frank Bloch to give a lecture, a dialogue, or something like that. In this meeting, or excellence meeting, from the Valencia campus, or International Valencia Campus of Excellence. Frank Bloch is well known for all of us, I think, but I have to introduce you. He's a professor from Vanderbilt Law School. He's an internationally prominent expert in social security. His field of research and work by years, and that will be enough, I think, to stay here. But he's also a leader in the international clinical legal education movement, and most notably as one of the founding members of the GATE, the Global Alliance for Justice Education. Professor Bloch has served as Fulbright Professor at Delhi University in India and as a research fellow at the International Social Security Association in Geneva. He's currently serving as a consultant of the USA Agency for International Development Projects to train Chinese law professors in teaching professional skills and clinical legal education. Over the course of his career, he has served as vice chair of an Institute of Medicine committee studying the Social Security Disability decision-making process, as a consultant for the Administrative Conference of the United States and the Social Security Advisory Board, and as a chair of the American Bar Association's Income Security Committee. He joined the Vanderbilt Law Faculty as Director of Clinical Education in 1979 from the University of Chicago Law School, a position held until 2001, and he also served as the Director of the Social Justice Program from 2007 to 2010. Before he began his academic career, he worked as a legal aid lawyer with California Rural Legal Assistant. And at Vanderbilt, Professor Bloch has taught courses on social security, poverty law, social justice, evidence, and civil procedure, as well as a life client clinical course on civil practice. Professor Bloch retired from the Vanderbilt Law School faculty in 2011. In this dialogue, if you prefer, in the framework of the excellence meeting previous to the 5th National Conference on Legal Education, and with the title Global Legal Clinics doing research, teaching, and fighting for social justice, Professor Bloch is doing an opening lecture to our 3rd Spanish meeting on legal clinics. 3 main points of reference in a global perspective: justice, doing research, and teaching, all 3 integrated. Thank you very much for being here. Thank you to the Valencia International Campus for promoting this meeting. Thank you.
Thank you, Pepe. I'm very glad to be here and to participate in this pre-meeting of the conference, and also to participate in the conference that's followed starting this afternoon. In preparing for this, we really didn't know how many people would come, what the background would be, and I think we're delighted actually that we have a nice small group. We're a family. I have the impression that everyone here has background and has an interest in clinical legal education. So rather than give a lecture, I do have some notes, and I would like to open the discussion with maybe some background and some thoughts on the topic. But then I have some colleagues here from the US and also experienced clinicians here from Spain, so we can open this up. And I've mentioned already that if anyone has corrections or comments to make while I'm talking, please feel free to join in. I think it's best to keep this informal, even though we're being filmed and recorded for posterity. Well, in the context of the Universities for Excellence, Pepe and I did talk about issues of research, of teaching, and also social justice. And so I thought I would talk about that in the context of what I see as three distinctions that are often drawn in legal education relative to clinics. These are sort of either or, black or white, dichotomies, one side or the other, that I think are false. And I hope in the course of discussing this we'll see that these are false dichotomies, but nonetheless they exist in my experience from what I've both experienced and also seen in the development of clinics everywhere in the world. So let me first give these three dichotomies, these false dichotomies, distinctions, either or, that come into legal education relative to clinics, and then I'll use these same three dichotomies to talk a little bit about just the background of clinics, to maybe bring us all up to the same background understanding of where clinics have come from. Then I want to talk a little bit more in detail, a little bit more closely about how clinical legal education has helped reform legal education and move it toward excellence, and then we can finish by talking finally where to go from here, and I will maybe offer some words about GAGE and about the global clinical movement. So the three dichotomies that I've seen over and over and are still with us in many people's minds are first skills, learning about skills, professional skills, versus social justice. Either you're interested in teaching skills or you're interested in social justice, either or. Skills versus social justice. The other is teaching versus service. Either you're interested in teaching, you're a teacher, or you're interested in providing a service, you're a service provider. And then the third is research versus advocacy. Either you are a researcher, you're an academic, or you're an advocate, you're a lawyer. So we have these three distinctions that are so often drawn that in the past have been often a barrier toward developing clinics, but my position is that in breaking these down and understanding really what skills training, social justice, law teaching, service to the community, research and advocacy, what these all mean, really bring or make the case for clinical legal education as a basis for reform of legal education. So just a little bit of background about clinics. I'll speak to some degree mostly about what I know from the United States and the developments of clinics in the United States, but from other countries as well, just to sort of give some background about what we mean by clinical legal education. And starting with this distinction or this false dichotomy of skills versus social justice, professional skills versus social justice. Pretty much everywhere, I think, in the world, you could say that one or both of these, sometimes separately, sometimes together, but quite often separately, one or the other, has been the motivating factor for developing clinical legal education in the first place. Using the U.S. as an example, in the very early days of the notion of having a clinical program at a law school, which dates back to the early 1900s, it was pretty much skills. It was the idea of having a lawyer school, teaching people to be lawyers. So professional skills, professional competence. And this had something to do with a reaction to the fact that in the US, in the mid to late 19th century, there was essentially a takeover of legal education by the academics from the practice. It was most common to become a lawyer in the United States until the, I'd say, mid-late 1800s by apprenticing with a lawyer. You didn't go to school to become a lawyer. You went to a law office and you, through the apprentice experience, became a lawyer. But the universities essentially took over the training of lawyers and made it an academic study. And so this idea of bringing skills back into teaching was a reaction to that, sort of brought by a realist movement that sort of recognized that there is a real world element to what law is and what students need to learn law to be. But later, in what we really think of as the modern clinical movement, and I think it's the clinics that are still talked about today, some of us, including myself, were even participants in these early years in the late 1960s, mid to late 1960s, early 1970s. Social justice really became the motivator, and that had to do with a sort of a combination of events in the United States. The war on poverty during the Lyndon Johnson administration, the civil rights movement, and the anti-war movement in Vietnam in the early 1970s. These came together with some also questioning during the famous Watergate scandal of the Nixon administration, with unethical lawyers leading the way to a sort of demand to have sort of more socially relevant legal education. So those would be sort of two different ways of looking at it. We've had the experience of both in the United States. Certain countries, I used India as an example because, as Pepe said, I taught there for a year. Social justice was the clear early motivator in the 1960s, creating lawyers for the people, using law schools and legal education as a way of providing legal assistance to the poor. That was the sole motivator for the development of clinics there. In South Africa, the fight against apartheid was really what the early clinicians did in that country. So those are the ways in which clinic developed. And we see this in this dichotomy of either skills or social justice. But as we'll see later, what skills and social justice have in common as clinics sort of move toward a notion of not just professional competence, but professional responsibility and ethics. Okay, so now let's talk about the teaching versus service aspect of the background of clinics. Well, here I think we're seeing something to do with the sort of basic conservatism of the legal academy. As I mentioned, in the United States, the notion of law teaching, once it became university-based in the late 19th century, really became frozen in a single model, and that single model was books. You taught law out of books, and the books that you taught, in the United States at least, happened to be cases, decisions of courts, but that would be sort of similar to the lecture method of teaching in Europe and in most other countries. You teach out of a code, and it's, you're a teacher in the sense that you're conveying information, sort of and in the extreme version, it's a rote memorization, as I don't need to tell you, and it's a one-way sort of transmission of knowledge, which makes someone a teacher, and then a student is a student, and there's no other role really there. So the idea that a law teacher might also be involved in providing service, which is what a legal clinic does in many instances, in one way or the other, is a radical shift in terms of thinking in the law school world at least, but if you think about it in terms of other professional education, most notably medicine. In the US at least, social work is another very clear example where the incorporation of practice into teaching and the provision of service as part of teaching is commonplace. We end up with this distinction, this dichotomy again. Either clinics are there to teach or clinics are there to provide service. Now, if you think about the service model, what does a service model mean? And this gets to the notion of social justice. So the skills versus social justice, the teaching versus service, you begin to see that while these are in one way separate distinctions that clinics have had to deal with, they begin to merge. When we talk about a service model, in the sense of you're teaching while you're providing service, this is where we get to the idea of clients' real-world experience as being a context for learning. Whereas if you think of the skills side of skills versus social justice, there is a sense of teaching, or the ability to teach, not necessarily dependent on providing service. You have the teaching method in clinics of simulations, of role plays, exercises, where you're focusing on certain skills or certain things that lawyers do. And this comes face to face in this distinction now. Here we're talking about the teaching versus service. We have some institutional constraints that have always been in the background of clinics. Sort of the professional versus the academic. Are teachers lawyers? Are lawyers teachers? If you're providing service, are you teaching? If you're teaching, can you really, or should you even be providing service? In extreme cases, again, I'll use India as an example, the way the profession is structured, law teachers cannot practice law. In order to be brought to the bar, as they call it, in order to be able to enter into the court, you must be a full-time lawyer. And if you're a teacher, you can't be a lawyer, and therefore teachers can't be lawyers. That's an institutional barrier, obviously, to a service model clinic where teachers are prohibited from practicing, therefore the teacher cannot be engaged in service, and therefore you retain that distinction or that dichotomy between teaching and service. And then the other side of it is the history in the United States. It took a little while, but actually not that long, for every state in the United States to pass a provision of the laws regulating lawyers, because in the US lawyers are regulated by each state, licensing law students to enter the court and depending on the state, do any kind of a case, criminal case, civil case, a case before a jury, under the supervision of a professor. We call this the student practice rule. And of course, with that ability, there's the distinction between teaching and service can break down because not only can students practice under the student practice, but there are no restrictions for law professors to practice in the US. And so I literally, as a lawyer, worked with my students as co-counsel, providing service, and at the same time maintaining that teacher-student relationship. Okay, so we have now these two sort of aspects of the background of clinics coming out of an interest of including skills training, clinics coming out of the idea that social justice needs to be part of the law school experience. We have the idea of clinics as clinics as teachers. We have the idea of clinics as service providers. So let's look now at the research versus advocacy distinction. Again, I think this depends on how clinics have developed. When you have a service model, right away you're introducing advocacy into the academy. This is something that sort of flows naturally if you think about the fact that by including a service mission as part of a clinic, you're going to have the clinic doing advocacy, and that becomes part of the university's mission. But we also have the aspect there of challenging sort of the traditional role of academics. The kind of research, the relationship between research and any professional issues is often there's often a tension there. And I like to point to a well-cited or often cited article by a former colleague of mine when I was at Chicago, John Elson, who wrote an article against against scholarship. I think that was the title of the article, Against Scholarship. And he kind of took on the notion of traditional academic scholarship in the United States as having moved so far away from the mission of training lawyers, or even having an influence on the profession of law, and more toward the sort of personal or even often idiosyncratic interest of the professor, that it had, in a sense, perverted the whole mission of law schools. And he made a case for the hiring standards, for the promotion standards, and how the value of clinic was so devalued in that environment that the only way to really change the way law schools work was to abandon the emphasis on sort of academic research. And you could take that to the next step and say, well, law schools shouldn't be doing research at all other than just developing ideas about law as they would affect individual clients or would affect actual legal issues that need to be resolved. I did a little piece myself for the International Journal of Clinical Legal Education, in which I tried to understand what John was talking about, but instead of talking about against scholarship, I tried to make a case for clinical scholarship. And what I meant by that was, if you think about what lawyers do, lawyers are researchers. And if you think about what a clinic does, if a clinic is a service-providing clinic, if a clinic is dealing with issues of social justice, how do you serve your client? How do you move or advance social justice? The first thing you do is research. And your research is informed by what it is that you're presented with in the context of either, again, providing service or trying to advance social justice. And that, to me, not only provides a basis for emphasizing scholarship and research by clinicians, but it also, as it happens, is a way of sort of making the case that when you think about what clinics can do in terms of the academic mission of research, is that it can advance the sort of the understanding or the development of research agendas by the very fact that there is this involvement with the real world. There is the involvement with other disciplines, sort of the fact that clinics often will be dealing with doctors in the context of whether it's a social security disability work that I do, or HIV work that's done in many clinics. You work with other professions. You work with social workers. You work with scientific experts for producing evidence or for analyzing evidence. So there's an interdisciplinary element there, and also an empirical element, in the sense that you observe what's happening. You take in data, even if you're not necessarily doing it in a rigorous research fashion. You have exposure to data, and those data can inform the work that you do and the research that you might do. But once again, you come across institutional issues that have been part of the challenge of clinical legal education from the beginning. Is it a professional school, which is pretty much what law schools are in the United States, or is it an academic department, more like what you see in Europe and in Asia? There are deeply embedded status issues. There's also resource issues, both time and funding. So if we take now all of these pieces together, I hope that you can see that the development of clinics and what clinics do is both complex in relation to the established legal education world, but at the same time presents opportunities for reform. So what I want to do now is just briefly talk a little bit about how I see clinical education as having influenced education reform from these developments, from the fact that you have clinics that have developed and brought into law school skills training, social justice curriculum, has been involved with providing service to the community, and has integrated advocacy into the mission of the law school. Sticking still with these three distinctions, what the skills versus social justice distinction, or the skills and social justice dimension of clinics has influenced really is the curriculum. And what we see is a much broader scope of educating soon-to-be lawyers. Although here I have to, again, draw from my India experience, and I'm really not sure here in Spain, where also are in most European countries where, in fact, most countries of the world, where law is an undergraduate degree and not a separate professional degree as it is in the United States. You have academic academic departments, and not necessarily, at least in the India case, are all the students in a law school going to be lawyers. In fact, in India, the majority of students in a law school are not going to be lawyers, in the sense of practicing lawyers. They have a law degree, and then they'll move into administration. They may move into business, or but you're not really preparing a student for the practice of law. Which, if we go back to that John Elson article against legal scholarship, that's one of the points that he makes about the perversion of the mission of law schools. The mission of law schools is to prepare lawyers for the practice of law, at least in the United States. And if that's not your mission, then your curriculum is, of course, going to be different. But to the extent that there is a training of lawyers and trying to educate lawyers, or at least educate legally trained students, there's no question in my mind that this skills, social justice has vastly broadened the curriculum. On the lawyering side, there are just simply topics that were not part of the curriculum, certainly not part of the curriculum when I went to law school, including the well-known interviewing, counseling sort of series of courses, courses on strategic development of facts, even courses on applied evidence, and the development of facts. Even to the extent, and this touches on another one of the issues that's again becoming somewhat to the forefront in the United States, to the extent that someone is being taught or being trained to actually be a lawyer, well, yes, there's always been the idea that a lawyer must at some point learn what a lawyer does. The question is, when do they learn that? Do they learn it in law school, or do they learn it after law school? And so if you think about the expansion of the curriculum, we also have to keep in mind that there are going to be big differences if that curriculum takes place in the law school before you practice, or if that becomes part of either bridge the gap between the school and practice, or is something that you learn in some kind of an apprenticeship during practice. But nonetheless, there's been clearly not just the development, not just the awareness, but the actual development of a broader curriculum of lawyering through this skills aspect. And on the social justice side, while many people say, at least in the United States, all of law school is about social justice, that's clearly not true. And what clinics have done in the social justice aspect has been to focus not just an area or a field or a topic of social justice, but really to both incorporate and broaden ethics, professional responsibility, and the whole public role of what lawyers, the public role of lawyers. And then I think most importantly, which takes us to the teaching service part here, is addressing issues in the real world, addressing issues of social justice that are faced by people in the community. Now, teaching service and that distinction or that false dichotomy has raised within legal education reform methodology. I think the real influence on that dichotomy or that discussion has been methodology. The whole introduction into legal education of sort of hands-on, we talk about hands-on, experiential, interactive teaching. And again, what that does is comes from a basic idea that students learn, students retain, students engage in their learning when they're active. This has, I think, its greatest impact in teaching social justice, in the sense of interaction with real people, with real problems, understanding the political power of being able to help somebody through a problem or be able to affect how a community addresses issues of injustice, but also from the personal level, as we see students understand and experience what it means to actually help somebody, as opposed to just understand what a law can do. But it also has a strong influence on professional skills in the sense of making the learning of what it means to be a lawyer and what lawyers do become more relevant and more effective for persons who do intend to practice law. On the research and advocacy side, what I think clinics have done has added, and this comes out of the curriculum side too, of course, has added the lawyering process as a subject of research. I think that sort of moving the research agenda of the academy away from just doctrine and looking at what law is and how one law interacts with another, to, as I mentioned before, how law is affected by other disciplines, introducing the empirical insights into what research can be. But again, here we have this institutional barrier that I mentioned before, which in the United States, at least, has brought about a certain irony in the sense that one of the strongest institutional conflicts between the traditional academic faculty and the clinic faculty has been in the area of research, whether clinicians should be encouraged to research, what kind of research clinicians can do. And in the US, as research has shifted really away from doctrine, away from the kind of research that a lawyer does in a case, to look what the law is and how can I use that understanding of law in order to achieve a certain result or in order to make a certain argument in the law for my client, toward a broader interdisciplinary or empirical view of what it is that I want to research about the law. It's really in the clinics, and it's the clinical faculty who have the greatest exposure, because our law faculties, at least until recently, are not academically trained. I mean, this is part of the law school being a professional school and not an academic department. The typical law teacher had 3 years of law school, never earned a PhD, never did original research, knows nothing about methodology. Now this is changing, and you find in the recently hired law teachers in the United States an increasing number of law and academically trained professors. But to keep clinics on the side and to draw a distinction between what kind of research you do as a clinician and what kind of research you do as an academic sort of ignores the idea of this role that advocacy or advocates can have in developing the research agenda of the academy. Okay, well. Maybe before what I've tried to do so far is give some sort of background of where clinics came from, what clinics do, and how clinics have influenced legal education reform. I do have a few thoughts about where we can go from here, but maybe we could just ask maybe Catherine if you have something to add about from the United States, or if any of you would like to give me or give us a sense of whether this rings true, or how these dichotomies, again, the teaching versus service, skills, social justice, research, advocacy, how do these relate to the development of clinics for you?
I'd be happy to just throw in a little bit about my experience teaching for the last 30 years in the United States. Always, do I have to come here?
Yeah, why don't you come up here?
What Frank said was very much my experience, and when I came to Catholic University 30 years ago, I came with the idea of a service model. This is what I wanted to be. I wanted to be an activist lawyer. I came from a political background, and I saw law as something to work with to make social change. And I think working at a religious institution certainly has its pluses and minuses, but one of the things that was important, and I think this is true with all of our universities, that we had a social mission, and all law schools seem to have this mission, but we didn't really have anything to operationalize this mission except for the clinical program. So we kind of snuck into the law schools under this mission. So it's a good thing to be thinking about what the mission of your school is, and that could be a way to further what you want to do with the clinical program. And my school was in some ways very advanced in that it decided that it would make clinical teachers tenure track members of the faculty. So I taught for 10 years not on a tenure track, and I was happy, and I was doing good work. And then it became a political issue within the academic community whether clinicians should be on the outside of the university. And I think that most of the clinicians that started when I did liked being outsiders. So in some ways, we said, okay, we don't mind being outsiders, but then when the door opened, we said, okay, we're going to do that and we're going to make it work. So we became very motivated to change the academic structure so that clinicians were given the same kind of security, respect, opportunities that other academic faculty had. And so it's been an interesting journey, and now that economic times are very tough in the United States, you can kind of see we're still in the same battle. We thought we had won the battle, but we certainly haven't.
Yeah, these are dichotomies that don't go away.
Yeah.
There was, do I need a mic? Or?
Yeah.
Okay.
So maybe you can.
¿Podría demanar por favor un micro?
I wanted to make one quick comment based on the experience that Catherine and I had working with clinics, first in Poland and then much through Central and Eastern Europe and former Soviet sphere, as I like to put it. Because when we first started working with people at Jagiellonian University, who established really the first successful clinic in Central and Eastern Europe, and Philip Czernicki will be here later in the week. Poland, I think, is the most developed country in terms of clinical education. All public schools have clinical programs, most of the private schools. And this is in part because of the terrific work that Philip has done as being head of the national foundation that supports clinics. But when we were first talking with Polish academics, who are very traditional civil law academics, and the constant thing that was said is, well, you see, we teach the theory and then they get to practicing the apprenticeship. So we do theory, they do practice. And something that I feel very strongly about, which is a dichotomy, is that clinical education is theory about practice. I mean, the idea that it's not about theory is crazy, you know, because fundamentally you can't learn anything without theory. I mean, that's the way you learn. You abstract and then you apply a kind of theory. And in addition, in terms of what Frank was saying, clinical education has also made a tremendous contribution, I think, in terms of research about practice. I mean, a lot of different kinds of empirical research about what actually happens in terms of various law on the ground, how the cohorts actually function, how the law actually affects people, and also the notion of innovation in teaching, because in the United States, really, I think it's pretty fair to say that it was the clinical education that brought in different teaching methods that really, here, of course, the lecture, you know, had an iron lock. There, the Socratic method had an iron lock, and they both had their place and their value. But as a single, exclusive method of teaching, they also have their limitations. And you definitely see in the United States lots of innovations in teaching methods that began in clinics, but are now very much done in other courses. In our session on Friday, Catherine, the part of her session, our session she's doing on case theory, I know she's going to talk about the fact that that's something that can be done in any kind of large class. I mean, it's a kind of experiential application that very much can help students learn in, you know, in any kind of class that people are teaching. So I think some of these false, and the one last thing I want to say, because I see it in Poland all the time, I don't think, you know, Spain has the same kind of apprenticeship system they do, but essentially the universities have just let themselves off the hook by saying, okay, we do theory, they do practice, and Polish academics, at least to me, seem to have absolutely no feeling of responsibility for the profession. You know, that's somebody else's problem. And if the profession isn't well trained, if the profession doesn't have a sense of social justice, that's not our problem. We teach theory. You know? And the reality, which I think is coming more and more clearly in Poland, is as finally they've opened up access to the profession, because they used to be a little closed nepotistic club, but the profession is overwhelmed. The profession can't run an apprenticeship program. And outside of the UK, Canada, Australia, Germany, maybe, I don't think that there's an apprenticeship program out there today that's worth anything. As I say, they're mediocre at best and corrupt at worst. And that's certainly true for what to some degree has happened in Poland. And so I think, you know, it's too bad if you have, I mean, the universities, I think, have to take some social responsibility for what happens in terms of what happens in a justice system.
Anyone would like to make any comment or question, because one of the points that sorry, I don't remember your name.
Catherine.
Catherine talked about is about the religious aspect of your university, because it's quite interesting, because in Spain most of the university are not has not religion orientation, but we have with us two members of one Catholic university, and maybe it would be interesting to hear. I mean, obviously, it's not. I'm not anyone in the room. Maybe could share with us. I mean, the reflection they did when they started with this legal clinic project. It could be in Spanish. So.
En español.
Yeah.
Bueno, buenos días a todos.
Espera un momento que... No, tenéis micro,
Buenos días a todos, soy Concha Molina, soy de la Facultad de Derecho de la Universidad Pontificia Comillas. Carlos Prieto que es de nuestro servicio de compromiso solidario. Somos una universidad católica, pero una universidad católica encomendada a los jesuitas. Nuestra universidad habla de nuestra clínica jurídica. La verdad es que empezamos en el mes de julio, o sea que venimos a aprender de vosotros, que tenéis más experiencia. Ni siquiera la tenemos internamente todavía constituida, aunque queremos empezar ya. Nuestra idea, nuestro punto de partida, la verdad es que surge de la confluencia y de alguna relación que tenemos la Facultad de Derecho con el Servicio de Compromiso Solidario y Cooperación al Desarrollo, comillas solidario, que bueno, se ha unido en este momento en el tiempo. Me ha parecido muy interesante la ponencia y me ha llamado la atención lo que comentaba Catherine, ¿no? Nosotros tenemos esa vocación de justicia social. Nuestro programa, en nuestra Facultad de Derecho, tenemos prácticas integradas en el programa, como todos los demás, y tenemos un programa de prácticas que funciona estupendamente. Nuestra idea no es utilizar la clínica jurídica para, de alguna manera, fortalecer ese programa de prácticas, sino que nuestra pretensión desde la clínica jurídica es utilizar las prácticas, y así lo estamos denominando, como prácticas solidarias. O sea, que nacemos con esa vocación de servicio a los más desfavorecidos. Es algo que es muy propio de nuestra vocación, de nuestra misión universitaria, como Universidad de la Compañía de Jesús, y esa es lo vamos a focalizar en esa idea de justicia social, que a lo mejor no entendemos exactamente lo mismo, porque está más volcado hacia la idea de ayuda al desfavorecido. Como la ayuda al desfavorecido es complicada, directamente lo que estamos es tratando de canalizarlo a través de las organizaciones de carácter social. Tenemos diversas organizaciones de carácter social que estaban ya trabajando con el Servicio de Compromiso Solidario, y lo que vamos a hacer es ofrecer servicio de apoyo jurídico a esas organizaciones con nuestros alumnos. Voy a ceder a Carlos la palabra porque es algo que llevamos a medias. La clínica jurídica es de la Facultad de Derecho, pero unidos y de la mano con lo que es comillas solidario.
Solo un par de apuntes rápidos, eso desde la humildad absoluta de estar recién llegados de una primera reunión con alumnos de la Facultad de Derecho para presentarles el proyecto y estar intentando para la próxima. La clínica jurídica de la Facultad de Derecho ha sido, como decía Concha, una confluencia con un programa que desde el Servicio de Compromiso Solidario estábamos intentando poner en marcha para todo el alumnado de la universidad, y la verdad es que la respuesta de la Facultad de Derecho haya sido extraordinaria, que nosotros estamos llamando aprendizaje-servicio, y yo creo que esto tiene que ver también con algo de lo que se estaba comentando. Es decir, no vivimos en esa dicotomía, o intentamos que no haya dicotomía entre el componente de compromiso social y de trabajo por la justicia social con el componente de aprendizaje. Para nosotros es clave la cuestión del servicio, pero entendemos que una práctica, una forma de aprender de esta manera es aprendizaje, es relevante como aprendizaje, y además tiene un componente adicional en el aprendizaje, que eso entiendo además que forma parte, quizá por ahí venía la pregunta original, de lo que identitariamente nosotros creemos que tenemos que ser, que es ser formadores de gente con un conocimiento de la realidad social, con una capacidad de conciencia de que sus acciones, sean las que sean, en un sentido o en otro, personales y profesionales, tendrán una repercusión en la sociedad que vamos construyendo. Entonces, para nosotros es importante el componente de servicio, es importante el componente de aprendizaje, porque entendemos que esta es una forma real de aprender sobre la futura profesión, y es importante que dentro del componente de aprendizaje ese se dé en esos ámbitos concretos, donde las habilidades profesionales además se ponen en juego en general de una forma más acusada que en otras situaciones, porque los problemas son más complicados, y además haciéndose cargo, o por lo menos tomando conciencia de una parte de la realidad que a veces queda oculta o no es tan conocida, particularmente de nuestros alumnos de nuestra.
Was there any others?
Yo me habla ¿en qué? ¿En inglés?
Thank you so much. That was very interesting. Creo que voy a seguir en inglés, porque las notas están en inglés. I'm just going to be very up nose and keep in English. Sorry. You were saying on those dichotomies and how you feel about that. When you say research and advocacy, I think that also has to do with the way of understanding research. And I've always done, I'm very close to social legal studies, and that's the way I've been, introduced into the academy and in jurisprudence, which is what I actually teach. But I think if we think of doing research and doing theory as being as doing critical theory, then you do need necessarily to be linked to the practice and to be linked to reality. The aim of doing research is to improve actually the practice and to make sure that you know where the law is lacking to provide the protection that it should, and then to improve it. So that dichotomy has to do with a very narrow way of understanding research in law and doing research for teaching law. So I always thought, that this was like going back and forth. But on what is our mission, that is the key. And we had to go through this process of thinking what the law school should do a couple of years ago with the Bologna process. And at the end, that was so frustrating to me because we ended up reproducing exactly what we had because of those status, power problems that are embedded there and all those issues. But at the end, our mission, I think, is to form those who will be responsible of the law and the justice in the following years. And that is also part of the service the university has to provide to, we are responsible, like Leah was saying, we are responsible for what the law is and what the law will be and what students will be able to do with the law. Now, there's a number of things they can do and a number of ways they can use the law with. And I think the clinical education is very good to show them that one of those ways is linked to social justice. And that, of course, you can make a lot of money or you can choose to go another way. But I think the law faculty has to show students that there are many ways of practicing law. And it's not just one way of understanding the law, of practicing it, and of, becoming a lawyer or whatever you are going to become later on. So it is our responsibility, if you are in clinical education or not, as a school of law, to provide all those models for the students.
No, just agreeing with Ruth.
No, I have, when I was hearing you, that is very interesting, we have talked about this before, but the problem from the point of view of the Spanish institutionalization, I don't know, the idea is, if we take a kind of department of clinics to do that, probably it will be the worst road. Why? Because we'll be considered as a part of other department with other subjects, and with all the false aspects of your dichotomies. But if we take other road, for example, a kind of program, not a course, okay, in the sense that more than a course, more than a module, I don't know what you say, a program in the sense that we have some goals to cover, and these goals include more than one subject, more than one department, that will be good. But our problem, I think, is here in Spain, probably it will be better don't move nothing, because if we change the curricula or whatever, it's worse for all of us. And in our case, for subjects, sure, we disappear from the curricula in one moment or other. So I don't know, what do you think? What is the best, to be considered as a professor, as a clinic professor, or as a social security professor who teaches not only that, but in a program that has some kind of coherence into the curricula. So, well, it's not a question, it's a reflection. Probably we have to think that, because probably the clinics will be a fashion in the next reform, and we have to decide something. Probably.
Well, I know we're running out of time, so all these comments really sort of take what I was going to try to summarize anyway, which was where to go from here, and I think a lot of this is a question of integration. And Leah mentioned this idea of integrating the clinical method into traditional curriculum. This is one of the new missions, or in the last few years, has been a big mission within our clinical community. And also on the question of merging the academics and the scholarship and the research and sort of bringing everything together. I think the other contribution, which I didn't mention, of clinics, but I think if you really look at maybe in a different categorizing, what have clinics, what makes a clinic or a clinician, what makes a clinical program? We certainly have the social justice aspect, which is something that clinics, clinical educators, I think, worldwide, to my view anyway, what makes us a community, what makes the global clinical community is a shared interest in social justice as part of legal education, as part of preparing lawyers for the practice, as part of our responsibility for training the future profession. So there's the social justice piece. And then there's also, however, I think, this education reform, the idea of reforming legal education. I don't think it's an exaggeration to say that almost all of the thinking about changing and reforming the legal academy in the United States has come from clinicians. It just was not an issue. And so if I understood, Pepe, what you were saying, I think that what you have to do anywhere is how can you best move legal education in the direction you want to go. And that, to me, is the real mission of legal education reform. And that may mean that you have to go with an existing curriculum and existing traditions and then build from them. Or it may mean, in some other places, you have to move off and branch out and completely transform. But this role of reforming legal education, I think that is the second. Besides, there's the social justice bond, and then there's also this idea that we may do it differently. We don't know exactly what clinical education is going to do to change and to improve and to move legal education to a new level. But it has a role to play. I think that addressing this responsibility of preparing lawyers and perhaps integrating the ability to be concerned about social action, but also about social research, that is what clinical education and what clinicians and people who are interested in this movement can do toward raising the level of legal education and ultimately bringing up the profession so that it can serve the community. I would like to close out with another observation from my years of working with Indian law teachers who are facing major issues of both legal education reform and also of social action. And that is that two things. First, the idea that ultimately what the social justice mission of clinical education is to inculcate, is the word, to inculcate a sense, to give deeply, profoundly a sense of the public role of lawyer. That's what clinics can do. That's what clinical education can do. This is what my Indian colleagues aspire to do for the next generation of Indian lawyers. But the other mission is to have, and this is the word they use, to have a competent profession. Now, I don't know here in Spain, but certainly in the US and certainly in India, there are a lot of lawyers who are out there that are simply not competent. They're not competent in the sense that they don't have a real quality of doing what lawyers need to do and what lawyers should do. And that itself is a social action. So I think that if clinics, through whatever merging of these aspects that we've been talking about this morning, teaching, service, research, advocacy, skills, justice, if all of those can lead toward a curriculum, a mission of a law school that inculcates a sense of professional public responsibility and results in a more truly competent in the legal ethics, legal responsibility, and just lawyer research sense profession, then we're contributing to the future, and that's what I think clinical education can do. We started late, we finished late.
Thank you very much. Thank you very much.
I'm the chairperson. Okay, thank you, Professor Bloch, for your lecture. And now, ahora, sorry,
Okay, your turn.
I'm going to address. Ahora creo que tenemos la reunión de las clínicas jurídicas patrias. I mean, obviously, the American. No, I mean you can stay.
I'm interested. I'll sit down.
Okay. So it's open to everyone. So está abierto a todo el mundo. Con los todavía no hablo valenciano en la intimidad. Yes. An applause for Professor